I welcome you all to today's lecture on Legislative Function of Administration, Delegated Legislation. Delegated legislation has been defined by Solomon as that which proceeds from any authority other than the sovereign power and is therefore dependent for its continued existence and validity on some superior or supreme authority. Donamore Committee on Ministerial Power states that the term delegated legislation means the exercise of lawmaking power by the executive under the authority delegated to it by Parliament. The rules, regulations, bylaws, etc. made by the executive in the exercise of lawmaking power delegated to it by the Parliament. Jane and Jane explains term delegated legislation in two different senses. Firstly, the exercise by a subordinate agency of the legislative power delegated to it by legislature. And secondly, as subsidiary rules themselves which are made by the subordinate agency in pursuance of power delegated to them through legislation. The Supreme Court of India in Agricultural Marketing Committee versus Shalimar Chemical Works Limited held that delegated legislation is the legislation which proceeds from any authority other than the sovereign power and depend on source superior authority for its continued existence and validity. Now let us discuss the reasons for delegated legislation. Delegated legislation is not a new phenomenon. Ever since the statutes came to be made by Parliament, the delegated legislation also came to be made by an authority to which the power was delegated by the Parliament. It's no use going back into the pages of history or to look to the Statute of Proclamations 1539, under which Henry VIII was given extensive powers to legislate by proclamations. What is intended to be emphasized is that there has always been and continues to be need for delegated legislation. The exigencies of modern state, especially the social and economic reforms, have given rise to the making of delegated legislation on a large scale, so much so that a reasonable fear could have arisen among the people that they were being ruled by the bureaucracy. In Agricultural Marketing Committee versus Shalimar Chemical Works Limited, the Supreme Court has counted many reasons for the growth and development of administrative rules making. The reasons for giving delegated power to the government to make rules are many, but the most prominent and dominant reasons are: number first, the area for which powers are given to make delegated legislation may be technically complex, so much so that it may not be possible and may even be difficult to set out all permutations in the statute. Number second, the executive may require time to experiment and to find out how the original legislation was operating and thereafter to fill up all other details. Number third, it gives an advantage to the executive in the sense that a government with an onerous legislative time schedule may feel tempted to pass skeleton legislation. Now we will throw light on the factors responsible for the growth of delegated legislation. Lack of time for the legislature to shape legislative details which are technical in nature where administrative expertise is required. The subject matter of legislation being technical, complex and unsuitable for debate in the legislature. Democratization of rule-making process by providing for consultation with affected interests. The advantages of flexibility, elasticity, expedition, and scope for experimentation when the delegated legislation technique is employed. Further, socio-economic schemes being experimental in the initial stage and the practical difficulties at the stage of implementation cannot be foreseen. Delegated legislation technique has the attribute of adaptation to unknown future conditions without formal legislative amendments. Now friends, we will be discussing types of delegated legislation. Delegated legislations may be classified into two broader categories. The first one is often called as title-based classification, which includes rules, regulations, order, directions, and schemes. The second category of delegated legislation referred as distinction-based classification, which includes subordinate legislation. The process consists of discretionary elaboration of rules and regulations and conditional legislation. The distinction between conditional legislation and delegated legislation is clear and unambiguous. In a conditional legislation, the delegate has to apply the law to an area or to determine the time and manner of carrying it into effect, or at such time as it decides, or to understand the rule of legislation. It would be a conditional legislation. The legislature in such a case makes the law, which is complete in all respects, but the same is not brought into operation immediately. The enforcement of the law would depend upon the fulfillment of a condition, and what is delegated to the executive is the authority to determine by exercising its own judgment as to whether such conditions have been fulfilled or the time has come when such legislation should be brought in force. The taking effect of legislation, therefore, is made dependent upon the determination of such fact or condition by the executive organ of the government. Delegated legislation, however, involves delegation of rule-making power of legislation and authorizes an executive authority to bring in force such an area by reason thereof. The discretion conferred on the executive by way of delegated legislation is much wider. Such power to make rules or regulations, however, must be exercised within the four corners of the Act. Delegated legislation thus is a device which has been fashioned by the legislature to be exercised in the manner laid down in the legislation itself. Now we will discuss need for regulation of delegated legislation. The power of delegation is a constituent element of the legislative power as a whole under Article 245 of the Indian Constitution and other relative articles, and when the legislatures enact laws to meet the challenge of the complex socio-economic problems, they often find it convenient and necessary to delegate subsidiary or ancillary powers to delegates of their choice for carrying out the policy laid down by the Acts as a part of administrative law. The legislature has to lay down the legislative policy and principle to afford guidance for carrying out the said policy before it delegates its subsidiary powers. In Avinder Singh versus State of Punjab, Justice Krishna Iyer laid down the following tests for valid delegation of legislative power. Number first, the legislature cannot efface itself. Number second, it cannot delegate the plenary or the essential legislative function. Number third, even if there be delegation, parliamentary control over delegated legislation should be a living continuity as a constitutional necessity. It was further observed as under, I quote, "While what constitutes an essential feature cannot be delineated in detail, it certainly cannot include a change of policy. The legislature is the master of legislative policy, and if the delegate is free to switch policy, it may be usurpation of legislative power itself." Unquote. Now we will discuss the methods of controlling delegated legislations. The methods of controlling delegated legislations are parliamentary control, procedural control, and judicial control. Parliamentary control refers to various control mechanisms provided either in the general rules of parliamentary proceedings or given as a part of Parent Act. These controls include laying in the House the subordinate legislation and subsequent proceedings thereof. In Messrs. Atlas Cycle Industries Limited and others versus State of Haryana, the Supreme Court stated about the procedure generally followed when an order or notification is laid before the legislature. These are laying which requires no further procedure. laying allied with the affirmative procedure and laying allied with the negative procedure. The court observed that the object of requirement of laying provided in enabling acts is to subject the subordinate law-making authority to the vigilance and control of the legislature. The degree of control the legislature wants can be noticed on the language used in such laying clause. Now we will discuss the procedural control, pre-drafting, hearing and publication. In B.K. Srinivasan and others versus State of Karnataka and others, Supreme Court observed that unlike parliamentary legislation which is publicly made, delegated or subordinate legislation is often made unobtrusively in the chambers of a minister and a secretary to the government or other official. It is therefore necessary that the subordinate legislation, in order to take effect, must be published or promulgated in some suitable manner, whether such publication or promulgation is prescribed by the parent statute or not. It will then take effect from the date of such publication or promulgation. A constitutional bench of the Supreme Court in Messrs. Shri Sitaram Sugar Company Limited versus Union of India held that legislative action, preliminary or subordinate, is not subject to rules of natural justice. In the case of parliamentary legislation, the proposition is self-evident. In the case of subordinate legislation, it may happen that Parliament may itself provide for a notice and for a hearing, but while the legislature has not chosen to provide for any notice or hearing, no one can insist upon it, or it will not be permissible to read natural justice into such legislative activity. In State of Tamil Nadu versus Krishnamurthy, the Supreme Court held that a delegated legislation, though legislative in character, will be invalid on the ground of violations of principles of natural justice if the enabling act under which the delegated legislation is made specifically requires observance of the principles of natural justice for doing the act. Now friends, let us discuss the judicial control of delegated legislation, principle and procedure. While considering the validity of delegated legislation, the scope of judicial review is limited, but the scope and effect thereof has to be considered having regard to the nature and object thereof. The nature of delegated legislation can be broadly classified as number first, the rule-making power, and number second, the grant of exemption from the operation of a statute. In the later category, the scope of judicial review would be wider as the statutory authority, while exercising its statutory power, must show that the same had not only been done within the four corners thereof, but otherwise fulfills the criteria laid down thereof. The courts therefore will require due proof that the rules have been made and promulgated in accordance with the statutory authority, unless the statute directs them to be judicially noticed. In the absence of express statutory provision to the contrary, may inquire whether the rule-making power has been exercised in accordance with the provisions of the statute by which it is created, either with respect to the procedure adopted, the form or substance of the regulation, or the sanction, if any, attached to the regulation. And it follows that the court may reject as invalid and ultra vires a regulation which fails to comply with the statutory essentials. Delegated legislation is open to the scrutiny of courts and may be declared invalid particularly on two grounds: violation of Constitution and violation of the Enabling Act. Rules made under the Constitution do not qualify as legislation in true sense and are treated as subordinate legislation and can be challenged in judicial review like delegated legislation. The framing of regulation is subordinate or delegated legislation and has to specify the following litmus test. Number first, it must conform to the provisions of the statute under which it is framed. Number 2, it must come within the scope and purview of rule-making power under the statute. The Supreme Court of India in the Delhi Laws Act 1912 held that legislatures in India have been held to possess wide powers of delegation, but subject to one limitation, that a legislature cannot delegate essential legislative functions which consists in the determination of the legislative policy and of formally enacting that policy into a binding rule of conduct. Now let us discuss essential policy formation test. The question as to limits of permissible delegation of legislative power by a legislature to a subordinate authority has come before Supreme Court in a number of cases, and the law as laid down by the court is not in doubt now. Considering the complexity of modern life, it is recognized on all hands that legislature cannot possibly have time to legislate in every minute detail. That's why it has been recognized that it is open to the legislature to delegate to subordinate authorities the power to make ancillary rules for the purpose of carrying out the intention of the legislature indicated in the law, which gives power to make ancillary rules for the purpose of carrying out the intention of the legislature indicated in the law, which gives power to frame such ancillary rules. The matter came before Supreme Court for the first time in the Delhi Laws Act 1912. The opinion in case has with the passage of time become crystallized. In this case, two views were broadly propounded. Justice Patanjali Sastri was of the view that the Indian Parliament, acting within the limits circumscribing its legislative powers, intended to have plenary powers of legislation as large and of the same nature as those of the British Parliament, and no constitutional limitation on the delegation of legislative power to a subordinate unit was to be found in the Constitution Acts. The Indian Parliament is therefore competent to make a law delegating legislative power both quantitatively and qualitatively, as is the British Parliament, and in the absence of any constitutional inhibition, delegation of legislative power, however extensive, could be made so long as the delegating body retained its own legislative power intact. But for the effacement of its power, a positive enabling provision in the constitutional document was required. The learned judge further observed that the court cannot strike down an act of Parliament as unconstitutional merely because the Parliament decides in a particular instance to entrust its legislative power to its appointed instrumentality, however repugnant such entrustment may be to the democratic process. On the other hand, Chief Justice Kania was of the opinion that the essentials of legislative function are the determination of the legislative policy and its formulation as a rule of conduct. If the legislature, having made its laws, leaves the details for working out and for carrying an enactment into operation to another subordinate agency or to some executive officer, there is no delegation of legislative power. If full powers to do everything that the legislature can do are conferred on a subordinate authority, although the legislature retains the power to control the action of the subordinate authority by recalling such power or by repealing the acts passed by the subordinate authority, there is still an abdication or effacement of the legislature conferring such power. In Vasantlal Maganbai versus the State of Bombay, the question of delegation of legislative power arose. This court enunciated the principle thus, I quote, "Although the power of delegation is a constituent element of the legislative power, it is well settled that a legislature cannot delegate its essential legislative function in any case, and before it can delegate any subsidiary or ancillary powers to a delegate of its choice, it must lay down the legislative policy and principle so as to afford the delegate proper guidance in implementing the same. A statute challenged on the ground of excessive delegation must therefore be subjected to two tests. Number first, whether it delegates essential legislative function or power, and number second, whether the legislature has enunciated its policy and principle for the guidance of the delegate. While concluding, it may be pointed out that it has been the most complex question for judiciary to exercise control over delegated legislations. If the Parent Act has made the policy guidelines very explicit, then there may not be any problem in regulating rule-making powers delegated to the executives. However, when such policies are either not clear or too complex, judicial scrutiny has been always limited to find out ways and means to show policy enshrined in the Parent Act or no policy at all. In no case, court can substitute its own wisdom and lay down policy thereof. With these words, I conclude today's lecture. Hope you have understood fully. Thank you.